morning, Your Honors. May it please the Court, Counsel. South Dakota must have a prison because the state action at issue in this case was, in selecting the future prison site, was discretionary based on validly delegated legislative authority. The state is immune from suit in this action based on its sovereignty. Absent sovereign immunity, the construction, maintenance, and operation of a prison constitutes an essential governmental function. And this court has held that such an essential function cannot be obstructed by local zoning laws. The circuit court found in favor of appellees on these issues, and we respectfully request that this court affirm that decision. I begin with sovereign immunity, as the state's position is that issue is dispositive. The state is immune from suit absent legislative consent. That consent can either be explicit or it can be implied. This court has found that the legislature implicitly consents to suit where it provides ministerial duties or directives to state actors. The reason that this court has made that distinction between ministerial and discretionary functions is that failure to follow a ministerial directive from the legislature is outside the lawful authority of that state actor. So such actions would not be protected under sovereign immunity. This court considers a ministerial duty to be a governing rule that is so clear that it eliminates the need for judgment or discretion by the acting officer. Essentially, it allows the state agent to determine the how and the when of implementing a rule. A discretionary rule, contrarily, is one that falls outside that narrow scope of ministerial duties. So, as I said, sovereign immunity does not apply to ministerial duties as the government can be compelled to perform them. This court has found that such a specifically described duty, when it is not followed by the state actor, does not merit the protection of sovereign immunity.
Well, what about Mr. Swanson's argument that HB 1017 just doesn't say anything about it, and so that's really not dispositive of anything? And you know, he would probably, or maybe has argued, in addition to that, HB 1017 comes against the backdrop of the Lincoln County case from the 1970s, where a different case, perhaps, but where this court indicated that an inclination to balance the interest, the relative interests of governmental entities. So maybe the silence means we should apply the balancing of interests.
Your Honor, I would interpret that silence to mean exactly the opposite, frankly. And the reason for that is because this court, or the legislature, is presumed to be aware of this court's decisions. And not only was HB 1017 passed in 2023 with the backdrop of Lincoln County v. Johnson, as the Justice points out, but also with the backdrop of City of Rapid City v. Pennington County, in which this court adopted the common law general rule when it deals with or when the court was dealing with entities that were not extraterritorial and were not intruding. And the state's opinion is that's the key distinction that analogizes the present situation with Pennington County, or City of Rapid City, and likewise distinguishes it from the Lincoln County case.
There was a reference in that case, though, to a statute, a specific statute, and it also seemed the court was certainly looking at that. Whether it was looking at both, or that's ultimately where it landed, may be debatable. But what is your thought about the fact they were referring to a particular statute that addressed the issue there?
Certainly, Justice, and I appreciate that question, because that leads into what is a very important point in this matter. What truly was the holding of the City of Rapid City and Pennington County case, and how much did this court rely on those statutes, and how much did it rely on the common law general rule? I think it's clear from the decision in the City of Rapid City case that this court intended to adopt that common law general rule, again, in these unique factual circumstances. They're very different from Lincoln County. And quickly, in the Lincoln County v. Johnson case, we had the city of Sioux Falls attempting to construct I believe it was a sanitary or a sewage facility. Landfill, I apologize. Outside of the city's jurisdiction, but still within the county. In the city of Rapid City versus Pennington County case, we had the county that was trying to build a jail facility or modify a jail facility within the bounds of the city of Rapid City. And this court recognized that those are very different entities. One, in the Lincoln County case, we had the city venturing outside of its domain or outside of its jurisdiction. We also had it intruding into the jurisdiction of another separate governmental entity. Finally, it's important to note that both of those entities, in both the Lincoln County and the City of Rapid City case, were creatures of statute and were not the state government. But in the City of Rapid City case, Pennington County fully encompassed the City of Rapid City. And so it was not extraterritorial. Likewise, the county was not intruding on another entity because Rapid City was fully encompassed by Pennington County. Now, this point is critical in the analysis of this matter because in reality, Pennington County had other options because there are parts of Pennington County that exist outside the city limits of the City of Rapid City. However, there is no portion of South Dakota that exists outside one of the respective counties. So to establish county zoning as the gatekeepers of when and where a prison could be built could essentially prevent that prison from being built anywhere. And this was exactly one of the things that the court in the City of Rapid City was concerned about and why it adopted the general rule as a part of the interpretation of the statutes. But I think it's also important to note that the legislature repealed those statutes that were at issue in City of Rapid City. Again, imparting on the legislature the knowledge of this court's decisions, we can look at that and say the legislature recognizes that this court adopted the general rule, and so those statutes were no longer necessary because the general rule could be followed. Additionally, I apologize, those statutes talk about a 2/3 vote being necessary to overcome the other entity's decision. Under the statutes, if there was the intruding entity was denied the ability to build whatever structure or take whatever action they were looking at by the host entity, then that intruding entity could essentially override that via statute. But again, that required a 2/3 vote. So the argument goes that taking those statutes away acknowledged this court's reliance on the general rule.
You know, you mentioned a few moments ago about, and in your opening remarks were about an essential government function and this prison has to be built, and most recently, you know, this idea that the territorial scope of the state, of course, extends, you know, within its exterior boundaries everywhere. But as I read the complaint, the prayer here for relief isn't to stop necessarily the construction of the prison, at least not directly, but it's a due process claim. It's a claim to subject the state to the zoning regulations of Lincoln County, which would require this use, which would be non-conforming in this area, to pursue authority either through a conditional use permit or an application to rezone. So maybe that's indirect, but still I think the fact remains that this isn't a direct action to stop the state dead in its tracks from building a prison. It's an effort to obtain notice and an opportunity to be heard. Does that matter? Or do you disagree with that?
I certainly don't disagree with the court's characterization, Justice Salter. I think that is 100% accurate. I think the important distinction here, the relevant issue is that their desire for notice or that opportunity to be heard is not found in the statutes, and it's not found in this court's case law. essentially what this court said in the City of Rapid City case in adopting that general rule was that if we're dealing with an entity that is not extraterritorial and that is not intruding onto another entity, quite simply, the zoning ordinances just do not apply. And so the state had no obligation to follow, to seek a conditional use permit or anything of that nature based on the common law and based on this court's adoption thereof. And the statutes that were referred to, Chapter 11-2, those specifically apply to actions of the county. And here, the county, as appellants argued, has not acted, other than in their amicus capacity and providing their opinion to the circuit court, but they did not take any action to compel their zoning. So there's nothing here that would grant any jurisdiction under 11.2.
Does the county have a duty to do so? A ministerial duty? To enforce their own ordinances?
Your Honor, in all honesty, I don't know that I have an answer to that question, but I think that that's for another day, as that demand isn't made here. The state certainly has no ministerial duty to comply with those zoning regulations, but that's I believe that that's ultimately an issue for another day because that's not what's presented here.
Can you address the plaintiff's, argument seems to be heavily tied to the fact this is a declaratory judgment action. And we have the cases, they cite the Dan Nelson Automotive, Dakota Systems, where an individual can seek declaratory relief. Why isn't that type of scenario? And maybe it depends on how far down the line of their prayer for relief you go. But if it's just a request for is the state subject to the county zoning ordinance, understand your response to the merits of that, but can they seek that?
Certainly. Understood. Justice Devaney, again, the key there, it goes back to the court's question of whether or not a private right of action is present. The state's position is that the appellants in this matter do not qualify for or have not pled appropriately for a declaratory judgment action because they have not met the 4 jurisdictional requirements that are set forth in the Danforth v. City of Yankton case from this court. Essentially, the court stated that for a declaratory judgment action, the petitioning entity must provide or must plead a justiciable controversy, adverse interests between the parties involved, a legally protected interest on behalf of the person bringing the complaint, and ultimately the controversy must be ripe for consideration by this court. The state's position is, for reasons that the justices have already alluded to, that appellants lack that justiciable controversy and they lack a legally protected interest. Because
does it matter? Forgive me, but can I just interject this really quickly?
Absolutely.
Does it matter? I'm doing it. Does it matter that 21, 24, 3 and other provisions in the Declaratory Judgment Act seem to center upon declaring rights under something, a writing, a statute, something, more so than just an abstract, hey, this is how we see the field?
I think that's extremely relevant, Justice Salter, and I think you're absolutely right. I think that continuing that thought, not only are the appellants not asserting a right under a particular writing or document or a statute, but essentially what they're asking for is they're asking the government to do something. They're saying, Department of Corrections, you have to contact Lincoln County and follow through and either seek a conditional use permit or seek a variance. And this court has said that essentially that's not what a declaratory judgment is set out for.
So
and I would ask...
They're not seeking a declaration of their rights as much as you would say they're seeking a declaration of or compelling the state to act, or something that would compel the state to act.
You said that much better than I did,
I don't
Justice Salter, and I appreciate that. And I would direct this court to consider the case of Hostler v. Davison County Drainage Commission. I think that case is relevant because there we had an adjoining landowner who challenged the commission's decision to grant a drainage permit as an abuse of discretion, saying essentially that the commission didn't consider all items that were needed to be considered when it made that decision. What this court found was that rather than asking the court to enforce a right, or specifically he was not challenging an ordinance or seeking a declaration of his rights or his status or other legal relation. What he was doing was asking the court to void an administrative decision for failure to consider all necessary interests. Similarly, that's what's happening here. The Department of Corrections made an administrative decision to build a prison on this particular site. What appellants challenge is their failure to consider local zoning ordinances. Now, certainly, the state's position is that they have no need or obligation to consider those, but ultimately, a very similar claim was considered by this court to not be appropriate under a declaratory judgment action.
You need to wrap up, Mr. Flynn.
Understood, Your Honor. So very quickly, I would just say that I think that this would be more akin to a mandamus action because that's seeking to compel the state to perform a particular function or to take an action as opposed to enforcing some right. There again, just as with the sovereign immunity analysis, the mandamus can only apply to ministerial functions, so that similarly would not lie. I would state in conclusion that plainly stated appellants simply do not want this prison in their backyard, and they are attempting to use the county zoning laws to prevent that from happening. However, the state is not subject to those local zoning laws based on the common law general rule and this court's decisions, and they would not be able to perform their essential governmental functions if they were so held to those ordinances. Thank you.
Thank you, Mr. Flynn. Mr. Swanson, you can proceed with rebuttal.
Justice Salter, I think you were exactly correct in saying that the entire tenor of our complaint is a plea for due process. After 35 years of being a coexisting landlord with everyone else, including the appellants here, the state included, after getting this farm by its cheap, all under first the rural and public use district, and then in 1995, it was amended into the A1 district, where a public-owned and managed or operated facility, if I recall, became no longer a permissive use as it was back in the days of the Sioux Falls effort to build a landfill in Lincoln County, the 1977 case, to today it's a conditional use. Would require a conditional use permit, and that was a decision that the Lincoln County commissioners made when that amended ordinance was adopted in 1995. That'd be about 3 years after the state obtained title to this property by its chief. To say that their interest in having the right to a hearing when there's going to be such a major, potentially catastrophic change in use and operation of the widow Haug's former farm, that the due process interests mean nothing to the state, quite frankly, is startling. I can't believe they can so easily trample those interests. I find that incomprehensible. They cannot, other than pointing to this so-called general law, general rule exemption, I find nothing else that really supports it. He talks about, counsel has talked about City of Rapid City versus Pennington County. It's a case I've read rather extensively because it is the antithesis of what he is suggesting. When that case was decided, City of Rapid City said, you made a fundamental error here in the circuit court because you didn't apply the balancing of interest test. Justice Sabers in his dissent was almost beside himself, talking about the list of horribles because they didn't apply the balancing of interest test. But the majority opinion simply put that to rest by saying the Lincoln County against Johnson rule, balancing of interest, does not apply here because of that fundamental difference in 11-6-21, that override statute, which originally was one statute. It was broken apart into 3 statutes and then ultimately canned by the legislature, repealed in 2010 or 11. The fact is, the statutory lay of the land did not allow the court to comprehensively apply the balancing of interest test because it was meaningless. The county had the right to come in and override that determination. In no way did City of Rapid City retreat from the balancing of interest test. It simply decided it was not applicable. In fact, I don't even think the term general rule appears in that decision. They did not seriously, this court did not seriously consider that at all. I want to commend for this court's consideration the case of City of Temple Terrace, which this court used unusually warm language over in the Lincoln County against Johnson case back in 1977. The word, we commend this case to the parties and their counsel. Thought that decision was incredibly insightful. Said, and if I may quote, the decision of a person administering an outlying function of a state agency, this is at page 578 and continuing to 579, with respect to the site where this function should be performed is not necessarily any better than the decision of the local authorities on the subject of land use. The adoption of the balancing of interest test will compel governmental agencies to make more responsible land use decisions by forcing them to consider the feasibility of other sites for the facility as well as alternative methods of making the proposed site less detrimental to the local zoning scheme. Discussion by council of Pennington County being extraterritorial to Rapid City and how that worked out. When you're going to have a work release jail, I don't think you want it in some hinterland of the county. I think you want to have it where there are actual jobs, where people could be work released to. And I think that's part and parcel of the reason the county decided to put it in Rapid City and why they decided under that now repealed statute to go ahead and force the issue.
Mr. Swanson, your time's up if you want to wrap up.
All right, I will wrap up and urge this court to again consider adopting the balancing of interest test to all governmental entities, whether they have direct zoning power or not, and that would include the state and its agencies. Thank you.